Welcome back to Investigation. This is your host, Scoot, along with
Hatter.
And Cass.
and this is our second episode for our minis. Woo!
Yeah. Cass wasn't here for our first one. Because she's lame. No, I'm kidding.
Back off, Hatter.
And I think Hatter is going to start us off for this episode.
I am. So, I wanted to do a little something different. I know we talk about a lot of true crime cases. And so I wanted to do a mini dive into the American justice system.
Ooh.
Yeah. So, we're going to talk about like some of the different types of murder charges and what exactly they mean. For starters, the word homicide itself basically refers to taking someone else's life. And there are lawful and unlawful results that change its definition. Killing someone in defense of another person or as self-defense can be listed or described as a justified homicide. Killing someone who is committing a crime like rape, murder, or armed robbery can result in a justified homicide charge for yourself.
Okay.
Whether or not it is justified just depends on whether state laws permit lethal force as an act of self-defense. And it can, and typically does, vary state by state, along with all of the other definitions and terms that we will get into. There's well over 52 different jurisdictions, and all of them kind of have their own rules for how a murder charge can be labeled. There are also homicides that are not justified but do not result in a full murder charge. These are typically referred to as the umbrella term of manslaughter. There's two types of manslaughter, involuntary and voluntary. Involuntary manslaughter, this is when someone's intentional, reckless behavior can cause the death of somebody, like drunk driving, recklessly handling a firearm, or criminal neglect like that of a caregiver failing to provide necessary care, which results in the patient's death. In PA specifically, for this example, this can result up to 5 years in prison. Then there is also the voluntary manslaughter, which is the intentional killing of someone. However, the reason it's charged as voluntary manslaughter and not third-degree murder is that voluntary manslaughter usually results from a heat-of-the-moment kill, where you fully intended to kill that person, but it was sparked from high emotions, also called provocation. Basically, it's the justice system's way of saying, yeah, you still can't kill people, but we kind of get why you did. An interesting case example of this actually comes from Ohio, State versus Shane. On October 13th, 1989, at approximately 6 a.m., Robert Shane II telephoned the New Philadelphia Police Department to report the death of his fiancée, Tina Wagner. Robert Shane strangled his wife, Tina Wagner, when she verbally admitted to infidelity. She first denied it, then after repeated questioning from Shane, admitted to cheating on him. During the phone call Shane had made to police initially, Shane told the police officer, quote, "I'm the one who did it. She just drove me crazy and I choked her." The police would find Tina's body in the apartment that she shared with Shane and their infant child, with a red shirt wrapped tightly around her throat. Shane was indicted for murder and pleaded not guilty. During the trial, Shane testified that his wife's admission of infidelity provoked him, leading to a moment of uncontrollable rage. The trial judge basically explained to the jury both the murder charge and the lesser charge of voluntary manslaughter, which requires evidence of serious provocation. The issue the jury faced was whether or not that Shane's actions were provoked by sufficient circumstances to warrant a voluntary manslaughter charge. In the end, the jury decided that a verbal confession was not enough to provoke such a crime, and Shane was charged with murder. What is interesting about this case is it ended up changing how Ohio viewed voluntary manslaughter and prompted the court to develop a two-step test for reasonably sufficient provocation. based on the 4 requirements for voluntary manslaughter, which are reasonable provocation and actual provocation. If a reasonable person would not have cooled off between the provocation and the homicide, and if the defendant had not cooled off between the provocation and homicide. The court put this in place, explaining that factors 1 and 3 were objective factors, reasoning that the objective standards would evaluate whether the provocation was reasonably sufficient to bring on a sudden passion or fit of rage. Basically, it was saying, like, would a regular person have time to cool off between the incident that brought on these emotions and them actually acting out on them. Then, factors 2 and 4 were more subjective. Under the court's 2-step analysis, a trial judge would first see if the objective standard is passed. Then the jury may consider whether the defendant themselves was under the influence of a sudden passion or fit of rage. Also basically meaning, like, the first steps are to see if a regular person would have cooled off. The second steps are to see if the defendant themselves had time to cool off. And in this case, the court ruled that the words admitting to adultery were not enough to warrant a justified provocation. So he did not get a voluntary manslaughter charge.
Gotcha.
Now, third degree is weird. Third degree murder is kind of similar to involuntary manslaughter in the fact that this is a charge that results from reckless behavior. But a third degree charge is applied when the killing may have been accidental, but it's from a dangerous or criminal activity. So the exact reason you'd be charged with one and not the other is in the details of the situation. For example, while involuntary manslaughter is from recklessly handling a gun, brings to mind kind of like kids who are fucking around with a gun and it accidentally goes off, compared to a third degree murder charge would be intentionally firing into a crowd of people. You're not necessarily intending to hit someone, but you do end up killing someone. You know it's a reasonable outcome of you firing into a crowd of people.
Yeah, that makes sense.
Yeah.
So it's not just like reckless behavior. It's more along the lines of doing something that's a felony that you know could result in someone's death. Now, there are only 3 states that have a third degree murder charge. That is Minnesota, Florida, and Pennsylvania, so it kind of fits perfectly with this month. In Pennsylvania, there's a case that is pretty interesting, and it did result in a third-degree murder charge.
Ooh.
It kind of shows that it's purely up to the judge, jury, and details of the case on how a specific action would be charged. For example, I stated that drunk driving is usually considered involuntary manslaughter. However, in a 2019 case, Commonwealth versus Peters, he was convicted for third-degree murder after drunk driving and rear-ending a van, killing 2 of the passengers inside.
Oh.
The details of this case changed the charge from involuntary to third degree, as Peters had attended an open bar event, moved to 2 other bars, rejected offers for a ride from coworkers, and chose to drive. Multiple drivers reported his erratic driving, speeding, swerving, abrupt lane changes with no signaling, and approximately at 1 a.m. while traveling at a speed of 115 miles per hour.
Holy crap.
Yeah. Peters rear-ended a van on I-95, causing it to catch fire.
Ooh.
2 passengers were killed and 2 others were seriously injured. The jury convicted him of third-degree murder, aggravated assault, and other charges. His defense had focused primarily on the idea that he should not be convicted of murder because ordinary drunk driving, without more, even when it results in a fatal accident, does not show the guilty mind, as it is phrased, for a third-degree murder conviction. The jury rejected the defense and convicted him to a lengthy sentencing which he had appealed, but the court ultimately upheld due to the fact that he had been offered rides, he almost crashed into multiple other cars, and he did not brake until the last second before impact.
Oh.
Ooh,
Yeah.
yeah. No, I definitely understand that because, like I said, with the whole, literally, like, people did everything they could to avoid him driving home, and then him, like, just turning them all down. Yet that was definitely voluntary.
Yeah.
Yeah.
The court distinguished this case from other DUI-related cases by emphasizing that the defendant had multiple opportunities to recognize the risk he was creating but chose to continue his dangerous behavior.
Exactly.
Exactly. Now, like I said, third-degree murder only applies to 3 states. So in Pennsylvania, for example, the difference between third-degree and second-degree is that second-degree comes from crimes such as rape, robbery, or deviant sexual intercourse by force or threat of force, kidnapping, burglary, or arson. But there is still no premeditation to kill. So it's more of a result of these crimes being one step above those that would result in a third-degree murder charge. However, for most states, there is no third-degree charge, and therefore second-degree murder is the charge given to the cases where the death of someone did not have any kind of premeditation, and may have only been intended to cause harm rather than death. Even if they intended to kill someone at the moment of a crime, it may simply occur in the heat of the moment and isn't something they planned out in advance. Or it can also be the charge given to those who might not have actually intended to kill their victim. Instead, they may have only had the intent to cause serious bodily harm. So you can already see, not only with different states having different rules, but even within some of the states, there's a lot of overlap within these charges. Like second degree is given to those who have no premeditation, but that can also be voluntary manslaughter. So most of the time it trickles down to the motivation behind the crime. In Florida specifically, second-degree murder often applies when an individual is committing another felony, like burglary, during the killing, whereas voluntary manslaughter is typically assigned when someone kills irrationally or without thinking, like in the heat of the moment. And in PA, the definitions specifically are that second-degree murder involves an intent to kill but lacks premeditation. Third-degree murder includes cases where a person engages in conduct that shows a depraved indifference to human life, resulting in death. Voluntary manslaughter occurs when an individual intentionally causes the death of another person, but does so under the influence of intense emotions. But overall, the biggest sentence that can be handed out comes from a first-degree murder charge. Usually, a first-degree murder charge has to have 3 key aspects. It must be committed with some sort of intent to kill the person. It also has to be deliberate and premeditated, not a heat-of-the-moment situation. And it must have, quote, malice aforethought, which is the legal term that basically means that a person who committed the murder did so with an intent to kill and a general disregard for human life. These charges often result in the maximum sentence the state allows, such as 25 years, life without the possibility of parole, or in some cases, capital punishment, also known as the death penalty. Pennsylvania itself first legally divided murder into degrees in 1794 to limit capital punishment. A prominent case that shifted how we prosecute murders involved the disappearance and death of Gulielma, otherwise known as Elma, Sands, in 1799. This case was the first recorded trial in America. Elma Sands disappeared on the evening of December 22nd, 1799. Before leaving her boarding house that evening, Elma told her cousin Catherine Sands that she was going to be secretly married to Levi Weeks, who had been courting her at the time. A few days after Elma Sands disappeared, a young boy found the muff she had been wearing in the Manhattan well, and then on January 2nd, 1800, Elma's body was recovered from the same well.
Ooh.
Yeah.
So why didn't they think to look for her in the well the first time when they found the muff?
They probably either they did and didn't find her. It didn't clarify. There wasn't actually even much on this case, which is ironic because it's the first recorded trial, but in the case itself, it didn't really have much.
Ah, okay.
A grand jury indicted Levi Weeks for the murder of Elma Sands. Ezra Weeks, Levi's brother, was a prominent citizen, and through his wealth and connections, Levi was able to hire 3 of New York's most prominent attorneys, Henry Livingston, Aaron Burr, and Alexander Hamilton to represent him at the trial.
Well, how ironic.
The state's case was entirely circumstantial, and the defense produced witnesses who testified that Levi was in the company of his brother Ezra and other friends during the evening in question. Chief Justice Lansing told the jury that there was not sufficient proof against Levi to warrant a decision against him, but he did stop himself before delivering a direct verdict. The jury, deliberating for only 5 minutes, acquitted Weeks of the crime. Although the state had failed to establish its case, and Judge Lansing's instruction to the jury about there not being enough evidence was technically correct, him saying that to the jury was widely criticized. Basically, people were like, he would have been, or more likely, convicted if you didn't directly tell the jury that there was not enough evidence to convict him. Yes. So that's what, even though it was his job to say to the jury that there was not enough, and so he wasn't wrong in doing that, he also did stop himself from delivering a direct verdict, which is literally him being like, he's not guilty, just straight up, because judges aren't allowed to do that. This resulted in a lot of criticism against them because everybody was like, it's very obvious that he did it, but the case was entirely circumstantial, so they had no concrete evidence for it.
Nothing physical.
Yes. However, this case has been noted as helping define premeditated murder. So this is kind of like the snowball effect of how we got now where we have first-degree murder charges that need premeditation to be considered a first-degree murder charge. Now also, we talked about Ed Gein, literally last episode. I wanted to quickly touch on insanity pleas. In an insanity defense, the defendant admits the actions but asserts a lack of culpability or ability to blame that person based on mental illness. The insanity defense is classified as an affirmative defense, not a partial defense. An affirmative defense means that if proven with sufficient evidence, it will negate all criminal liability even if the person is proven to have committed these crimes. The affirmative defense essentially means, in most states, even if the person is technically guilty, he will be found not guilty and sentenced to a mental health facility instead, like Ed Gein. A partial defense simply mitigates the defendant's culpability. Basically, it lessens the ability to blame due to reasons like a heat-of-the-moment kill. Now, an insanity plea is also different from a diminished capacity defense, which not only do few jurisdictions allow, but it also has varying levels of support over time. A diminished capacity defense is usually presented with the goal of lessening the convicted crime, from murder to manslaughter, for example. This is based on the belief that certain people, because of mental impairment or disease, are simply incapable of reaching the mental state required to commit a particular crime. Using the example of murder to manslaughter, a diminished capacity defense would basically be saying that a certain defendant is incapable of intending to cause a death, so the death must have been caused by recklessness. In a 1979 case, California v. White, Dan White, a former city supervisor, shot and killed the mayor of San Francisco, George Machon, and another city supervisor, Harvey Milk. White had brought extra bullets, climbed through a city hall window in order to avoid metal detectors, and then shot the two men 9 times.
Wow.
That's a little excessive.
Yeah. White's attorney argued diminished capacity, claiming a diet of only junk food had created a chemical imbalance in White's brain, earning this type of defense plea the nickname the Twinkie defense.
No.
Oh, no.
No.
It's not funny, but it's a little funny. The Twinkie defense. White's attorney also claimed that he was depressed over his loss of his city supervisor position. Somehow this combination resulted in him being unable to premeditate his kills. I guess we're also going to ignore the fact that he brought extra bullets and took extra efforts to climb through a window to avoid metal detectors.
Yeah, exactly. I'm like,
Mm.
I was literally thinking, I'm like, no, like, if he was doing that in the way he claimed, that there's no way.
Yeah.
There's no way he would have thought of all that.
Having enough forethought to think to bring extra bullets as well as know that there's going to be metal detectors, there in and of itself shows a type of premeditation.
Yeah.
Like,
Yeah.
but I digress. The jury convicted White of voluntary manslaughter instead, which did cause a lot of scrutiny over the diminished capacity plea. And by 1982, voters overwhelmingly approved a proposition to eliminate the defense in California. However, California later allowed for a similar defense called diminished actuality, which allows for expert testimony of a person's mental infirmities that would prevent a person from intending to commit a crime that requires intent to be charged. So basically, they allowed for the same defense to come back under a different name. However, in this case, they do require expert testimony
Gotcha.
to prove it. So, yeah, there's a little dive into a drop in a ocean of water of the American justice system and how it works. It is a little bit confusing, to be honest, because, like I said, a lot of the different murder charges even have overlaps with them. So it kind of comes down to the baseline is like the details of the case, the motivations behind them, and things like that. The only one that pretty much every state agrees on is that first-degree murder requires premeditation. But then, they can't even agree on what punishment that should receive. Some places it's only 25 years. Some places it's for life. Some places it's life without parole. And other states it's the death penalty. So, yeah, that's my little dive into a little educational pod for you.
So that wraps up this episode for our mini episode this week, guys. So catch us next week on Sunday. Now, that episode is going to be a little bit of a mystery.
Ooh. This is the one that you sent us a pizza gift.
I did.
Yeah, that one.
A spoiler without context.
Yeah, so tune in. We might actually be eating pizza during this podcast too. This episode.
Now I'm hungry.
Actually, I am hungry, so that pizza sounds really good right about now.
So don't go too far, because we'll catch you in the next investigation. Bye!
Bye!
Bye-bye.
Grab your slice of pizza.
Grab your slice of pizza. During the phone call Shane had made to Panini. To Panini. Based on the 4 requirements for in an insanity defense. That was a bit of a twang twister.